Ladies and gentlemen, welcome back to Buying, Selling, and Everything Else. As we've been discussing the different steps of buying and selling, particularly buying, we went through with the very first step of getting your finances right, and I interviewed a broker who gave you immense of knowledge and stuff that you should be doing or things that should be considered before you even start looking. The very next thing that you need in your arsenal or in your tool belt would be a solicitor or a conveyancer. And we'll go through the differences about that, what's the difference between a solicitor and conveyancer. But let me stop talking and introduce my very good friend, John Christian from Victor Legal. He's been in the game for over 10 years. He knows his stuff. I trust him with my life. He has helped me in a number of cases and issues. But I want to start with how we became friends. John was actually not representing my client. He was representing the buyer. Mm. I usually work for the seller, so my client is the seller, right? Now, and it so happened that my client's solicitor didn't know as much as he should have.
Right.
Right. Brings us to the topic of the deed of rescission.
Yes.
Now, I personally don't believe that, like, everybody should know this in the game.
Yes.
Every agent, every solicitor, every conveyancer should know what's a deed of rescission. Unfortunately, that's not the case. So John helped us out through in a big way, guided both of us. She guided the other solicitor too.
For a while there, we were almost acting for both people because I just wanted to keep everything on track.
Yeah.
Which was a bit stressful, but I suppose the other added layer of complication with that case was that my client was a first home buyer.
Yes.
So talking about deeds of rescission and the complications with the contract added a lot of stress for her. So on two fronts, I was managing the transaction. I was fielding questions from you about why this isn't getting across the line as simply as it should be. Why isn't my
solicitor working?
Well, there was a few misunderstandings, and I just wanted to keep it on track because my client, first home buyer, she really wanted this unit. I wanted to keep it on track for her and just simplify everything. Unfortunately, it did take a bit longer than expected, but we got there in the end.
And this one transaction was a very simple example, like very, very, very good example of how a simple transaction can get complex and why a first home buyer or even someone buying the 10th property needs someone good, knowledgeable, experienced like yourself, I'd say, in their corner to make these transactions go through.
Right. At the end of the day, you're spending a lot of money, whether you're a first home buyer or a sophisticated investor.
Yeah.
Not many people can make up that sort of money if it goes wrong in a short period of time. It's going to have a financial impact on everyone. Also, there's the unknown factor of how complicated it can get.
Yes.
And people don't know how quickly legal fees can escalate.
Yes.
So we'll probably get to this, but
we'll talk about fees later.
Yeah,
yes.
We'll talk about research as well because it's a minefield to navigate when it comes to engaging a firm.
So let's. So the first question. This was going to be my last question, but things have changed up. What is a deed of rescission?
So the document itself looks a bit complicated. It's bland. It is a legal document. It's in the form of a deed, and it's effectively a document that sits in the middle of two contracts and acts as the portal to translate the terms from the first contract to the second contract and holds everyone accountable without the deal falling over. Where it is most commonly used is where people wish to change the buyer entity. So if it's a minor error, like the spelling of someone's name, you can just make the amendment on the contract, although you should consult with your solicitor about that.
Yeah.
But where perhaps you've signed up the contract on Saturday night and you should have put it in the company name or a trust name or your wife's name or something. In those sorts of cases, that's where we need a document to govern that change. So we prepare a deed, we note what clauses are staying from the contract, what clauses are going to change. Everyone signs that, and simultaneously they sign a new contract with the new entity, so a new buyer entity. Everything else will remain the same. So the purchase price, the property, the deposit amount, the settlement, all of that will remain. There's also some stamp duty implications for not doing this properly. So if it's done, if these changes are done with the deed, then there's protections for you in preventing the payment of double stamp duty.
Double stamp duty, yes.
However, if you proceed to make changes to the contract other than by way of deed, there could be stamp duty implications. So if it looks like your transaction is going in the direction of needing a deed, it would be recommended you speak with a solicitor and not a conveyancer.
Not a conveyancer.
It could lead to thousands of dollars extra out of pocket.
Fair enough. So just to recap, in this instance, what happened was, like John said, we signed the contract up on a Saturday afternoon. The buyer said, my name is John Smith, and we put it in there, and we got the contract, buyer signed it, seller signed it, everything was good. Only later to realize that middle names were missing, not only on the buyer side, but on the seller side, which was my mistake. I dropped that in when I was doing up the contract. And then when we were going to settle, we realized there were changes in the names that had to be done. So we needed the deed of rescission to replace or keep it all together, saying that these are the same people with middle names.
Right.
Yeah. Now, when you said about stamp duty, I just want to clarify, because I'm also, it's a bit murky for me. So if there are two contracts floating around, it is a high possibility that either the buyer or the seller would be paying double stamp duty. Now, the buyer could be paying double stamp duty because there are technically two registrations happening. Is that correct?
Well, the purpose of the deed is to effectively terminate that first contract by mutual agreement.
Okay, yes.
So that there is no stamp duty payable on that first contract.
Yes.
When you look into the guts of stamp duty rules, there's actually an obligation for stamp duty to be paid by the seller and the buyer. But the obligation for actual payment falls on the buyer, and it's calculated based on the contract price. But in our scenario, we needed the deed so that there wasn't two contracts.
Yes.
So we're only paying stamp duty on the second one.
On the second one, yeah. Okay, cool. All right. John, a lot of my first-home buyers or sellers also, because they're selling after so very long, they've not really dealt with a solicitor, conveyancer, or had to go through a transaction like this.
Right.
And I would suggest someone like yourself, it's like, hey, if they don't have a solicitor or a conveyancer, go like, talk to John. They then go onto Google and they Google some stuff.
Yes.
And you get solicitors and conveyancers coming up. So first, we'll get into the pricing later, but first I want you to explain the difference between a conveyancer and a solicitor. Is there any difference?
In my opinion, there is a big difference. However, at the end of the day, both a solicitor and a conveyancer can handle the same aspect of the transaction in terms of preparing the documents through to settlement. There's some legal rules around the signing of the electronic workspace that facilitates the change of ownership. But apart from that, for the most part, we can do the same work. Where it comes a difference is that, and the analogy I like to use is between a GP and a specialist. So a GP can deal with the everyday medical concerns of the public that walk through the door. They can give prescriptions, they can send you for a test and gather all that. And once they have a gut feeling that it needs to be referred to a specialist, they'll prepare a letter for you and you will go off and see your specialist. The reason for going off and seeing the specialist is that they can look at broader issues. They have specialist training and reading different medical results, and if need be, they can put you through surgery. So, of course, if the transaction goes smoothly and you use an experienced conveyancer and they work within a law firm umbrella in Queensland, then if you're price conscious, that might be an option you wish to consider. However, conveyancing in Queensland is governed, I think they say, by about 25 different pieces of rules and regulations, and it's changing all the time. At the end of the day, it's a large transaction. It's normally done within 30, 45, sometimes 60 days, where we're having to move hundreds of thousands of dollars between two entities. There's a lot of room for error. There's a lot of room for mistakes. It's generally done between individuals. I've never needed to engage in the legal process before. There's a lot of terminology for them to wrap their head around. And often issues come up on a Friday afternoon or a moment before settlement, which could have a catastrophic implication for the transaction. So I think it's worthwhile spending a bit more to engage a solicitor, because we can look at broader contract issues. We have an appreciation for the broader legal landscape. And if it is going in a direction, like the case you mentioned earlier, we can triage that without having to farm it off to another firm, because the big thing with conveyancing, as you know, in Queensland, time is of the essence. So if you're not properly prepared with a solid legal team from the start, but the other side is, they're not really going to have much wriggle room or consideration that you weren't properly prepared. So for not much more in terms of the legal fees, you'd get a lot more peace of mind and a lot more value out of seeing a solicitor to handle the transaction.
So the next step, and I was beating around the bush on this part. As I said, people go onto Google, they get a list of people over there, a list of conveyances that come right on the top over there, and which is great. I personally had an experience with one of my sellers who have picked a conveyancer that charged $299. So my first question, there'll be a few questions in this, but $299, it's very cheap, and anybody and from my point of view, you get what you buy, you get what you pay for it, right? How could they manage paying $219, like taking $299 over where standard conveyancing for a seller would be about $880, if I'm not wrong?
Yes.
It's a huge difference. Like it's less than 50%. How do they do it?
I've asked myself that question. And I can't say I know with certainty how they're doing it. I have a rough idea. But I think the problem is that's their upfront cost. That's like the shiny number on the car at the car yard.
To bring
what I've heard though is that's not necessarily the number you will pay at the end of it. So it might be more towards the 550, 650 mark, somewhere like that at the end of the day. But that's a hook. That's their marketing. That's their business model to get that traffic off Google. But what I've heard in the industry is that often they will charge you per phone call. They will charge you per email. They will charge you per extension notice.
Wow.
And I'm not sure where the schedule for all those prices are. Perhaps it's in the engagement agreement when the client onboards with the firm, but perhaps people miss it. So then they receive this bill shock just when they're about to settle, which there's enough to deal with if you're a firm handling a transaction for someone to also be trying to justify your price. So I think it's a marketing model adopted by my peers.
Because I had one where they were quoted $499 and they ended up paying $3,200.
Yes.
So
that was for all the extras.
$35 for an email.
Right.
So yes, it is one of the things. In my proposal, in fact, I actually tell people to stay away from that model, or actually ask about the fees and structure that going into it.
Yeah. Or perhaps even ask the question, is it fixed fee? Which is the model I operate under.
Okay.
Of course, if we're getting into a scope of work that's beyond what I've listed, and our engagement document's very clear in what's included in that fixed fee, but we're quite generous in
Yeah.
the time that we spend.
Yeah.
We do contract reviews for free,
Yeah.
Saturday afternoon, Sunday afternoon. So
You've
people,
done for me. Thank you.
yeah, so people can sign it
Yeah.
with peace of mind. They get a standard letter from me that has some of the top things to consider.
Yeah.
And we don't charge any extra. It's a value that we have instilled in the firm,
Yeah.
just so people sign up with peace of mind. At the end of the day, when you put the key in the door or you see the money in the account as a seller,
Yeah.
we want you to have a good time.
Yeah.
Often agents will bring like a settlement gift or something.
Yes.
Your family will be there to enjoy the experience. The last thing we want is
Some
you
more.
not enjoying your champagne when you put the key in the door.
Yeah. Because you're not covered.
Yeah.
So this is another thing. If you're a first-home buyer or even a veteran buyer, what I took out just now from John's explanation or answer to my question is read through the solicitor's engagement document.
Yes.
See what's in there. What is that solicitor or that conveyancer going to give you?
Yes. We don't want you to end up with bill shock.
Exactly.
Yes.
It's very general, but are there some pitfalls or some shortcomings that buyers and sellers should be legally aware of, or how do I put this, or they overlook these things and proceed that you'd give them, say, 2 or 3 tips that you need to look into this, this, and this.
I think on the buyer side, and it sounds cliche and not that important,
Yeah.
but they're absolutely important, particularly in these economic times.
Yeah.
And a lot of owner-occupiers are selling homes first time to market in 40
Yep.
or 50 years.
Yes.
Lovely homes, but they may be a bit worn down.
Yes.
So what I'm getting at is that finance and building and pest, unless you're Jeff Bezos,
Yep.
just include it.
Yep.
I'm hearing almost daily
Yes.
agents telling clients, buyers, that they don't need, that the seller won't agree to a building and pest, or they won't agree to a finance clause. If you want the property, you've got to buy it unconditional.
Yeah.
Well, my response to agents is if your client wanted to sell unconditional, so no finance, no bells or whistles to protect the buyer, then they should have taken the property to auction. You've come to market to entertain private treaty contracts, conditional contracts. So you need to allow the market to dictate.
So always have those conditions
Always
in there.
have them. There's
Yeah.
an additional third one I like to include, which
Yes.
agents are not a fan of, and that's
Yep.
particularly in the high-rise market, is a due diligence clause.
Due diligence.
In
yes.
the high-rise market, we're looking at all the body corporate affairs, all the body
Yes.
corporate documents, getting copies of all of that.
Yep.
It's normally a 500-600 page document. I like to say most body corporate strata companies charge about $1 a page, so it
Okay.
could add about $600
To the
to the
conveyancing bill.
conveyance.
Yeah.
But you'll be surprised what funny business goes on in
Yeah,
buildings.
exactly right.
And if you've got that general due diligence clause and you're not happy with the affairs of the building,
Yeah.
at least you can get out. But I think that also applies to established houses. You can look at a broader range. We can do pre-commitment searches, infrastructure or contamination or something like that, and you're
yeah.
not committed to the contract. And if you pull out, you can get your full deposit back.
Yeah. What kind of time period for due diligence would be an ideal, similar to finance and stuff like that? Or
I approach it that it should be at least 14 days.
at least 14 days, yeah.
Because often with certain government searches, they can't be returned
Yeah.
immediately. There's a turnaround time. So
Yeah.
we need to allow that lead time. And then we also need time to advise a client on the results.
Yes. Now, another golden nugget here. The first one we did speak about the engagement document that you need to read through it. And this is something, it's just like blows my mind every time when we do up a contract and people don't even know about this. I always suggest to my buyers, because I only sell apartments, right, to add a body corporate search. Now that is covered under your due diligence.
Yes.
So first-time buyers, downsizers, getting into an apartment, buying in a building, due diligence or a body corporate search is something I'd almost say a must. we generally say, just looking at a body corporate search, you can get a bit of a feel of it. Sinking fund balance, is equal to the health of the building, all that kind of stuff. But actually digging into that and actually, reading the minutes of the last body corporate meeting and stuff, it's so valuable. It gives you so much more insight.
Absolutely.
Yeah. We've kind of touched base on this a little earlier, but doing a contract up in Queensland, it's usually the selling agent that does up the contract, and it's again usually a standard REIQ contract.
Yes.
Now, do you think that as a seller, needs to have a read of that or send it to his solicitor before he signs it?
I always say that prevention is better than a cure.
Awesome.
A solicitor who works in the space doesn't need long to do that. It's probably 30 minutes to an hour once the agent sends through the draft contract.
Okay.
Because most firms should have precedents. We should know the questions that we can ask the client. The big thing for sellers, and particularly in the high-rise game again, is the disclosures you need to make. They're quite different from the disclosures that sellers of an established property need to make. The big thing is latent and patent defects in the common property. So we ask the question, do you know anything about the condition of the property? Are there any disputes about infrastructure or big capital expenditures coming up? Is there a big leak in the pool that you guys have been talking about at body corporate meetings?
Yes.
No, none of that. Okay, well, maybe just sit on it for 24 hours.
Yeah.
You've got the contract. Please read my letter of advice before you sign it up.
Yeah.
The agent will say the market's hot and we've got to get this
Absolutely.
signed up.
Yes.
Now we don't want to lose this buyer.
Yeah.
But if the buyer really wants it, the buyer will stay there.
Yes.
The buyer, if they're sophisticated and went to a lawyer and they're not bringing the problem to the table, they'll get really annoyed at you. If the price is right, they'll still stay committed. Yeah. And if you come unprepared as a seller, there's not only legal repercussions, but your unit may have sat by that time on domain or realestate.com for a lot longer than necessary. It's probably gotten stale. So I would say in those scenarios, the agent would say rip the property off market for a while. Just let the current set of interested parties dwindle away, and we'll get a new school of interested people.
Yes.
So for the sake of speaking to your lawyer for half an hour or an hour to save yourself against all of that, just flick it through to us. Let us have a chat. Look at the letter of advice, sign it up with confidence and move forward and settle on time and on budget and enjoy your money.
Wonderful. And usually these things are free.
Right.
Like just a read through of the contract and go, this is good to go, or add X, Y, and Z.
Right. And for us, I mean, that's $600 value. We've just added before you've spent anything or before you have even formally
hired you, isn't it?
Yes, that's right.
Yes. Okay, cool. With me, in the last 9 years, I really haven't had a contract fall over, like go away, just because of something. Like finance clauses and stuff, these things happen quite often. I haven't had many. But what do you think are the most common reasons, apart from the buyer not getting finance, contract falling apart?
So in my experience, in my practice, the reasons they have fallen apart is generally between two classes. Those that are sophisticated and know what they have done, so they've done a lot of due diligence. And those that are unsophisticated and thought that they would be getting a lot more than what they are getting.
Okay.
So the sophisticated ones have done every search possible. They may have spent $1,000 or $2,000. A common one that comes up is around infrastructure passing through the land. So there might be an urban utilities pipe or a sewage pipe or something similar to that, or NBN infrastructure that wasn't disclosed at the outset of the contract, and people had plans to build a granny flat or a pool to add value to the property or just have more features for the house. So those plans have been curtailed because now they can't build that infrastructure.
Okay.
And their argument in those cases would be they paid X dollars for the property because it had the opportunity for them to put in a granny flat or a pool or do a patio extension or something that they can't do now. So then there's an argument about misrepresentation or misleading and deceptive conduct by the real estate agent and the purchase price.
Yeah.
And then sometimes that leads to termination and a fight around termination, what it's going to look like, and in really bad cases it ends up in court.
Yeah.
The other side of the coin is unsophisticated clients. I had one not long ago. I acted for the buyers for a short period of the transaction because the buyer thought that the the white dust that was in the garage floor was representative of some mold or decayed mold or whatever it was, and she was sensitive to mold from a medical perspective, so she wanted to pull out of the contract. It came down to the wire. She ended up going back to the original firm that started the transaction, but that's a scenario where it could have fallen over very easily, and that was just due to a knowledge gap. There were certain searches done and statements and inquiries or whatever that meant that the buyer's rights weren't there. And just to that knowledge gap, they thought they had those rights, which they didn't actually have. So the reason that contract, from what I understand, stayed on foot was really coming down to the solicitors from both firms explaining in simple terms how the contract works, what your rights are, how far they go, and how certain events that have come to that point meant that you don't have those options that you thought you had. And then the common things are valuations were done by a bank. They don't stack up when you come to settle, so the bank either revokes its right to its offer to extend financing, and then they can't draw on financing. That's been softened a little bit now with the 5 business day extension, and they might go to the bank of mum and dad to get the money. So the reasons they fall over is more in the unusual cases than the cases you commonly think happen.
And this is where like due diligence comes in to play, I guess, because the standard conditions of a contract is for finance, you're building in pest, and that's pretty much the conditions for it to settle. And then you've got the due diligence clause where it really covers a buyer when something like this props up.
Right. That's right. And I think we're going to get to it in the next couple of questions, but we might go ahead because I know you wanted to talk about some of the changes that are coming up, but I think it's important to speak to the listeners. What Queensland has done, which is actually I think it's the first time in 50 years since they've changed the Property Law Act to the Property Law Act of 2023, which largely a lot of things from the current Property Law Act of 1974 will absorb. But the big thing for Queensland will be to align us with the other states where a lot of that disclosure is upfront and the responsibility of the seller to do. So from what I understand, between say offer stage and contract stage, so the exchange of contracts, there's a period down south where you need to go through that due diligence phase. So I think in most cases contracts are prepared in New South Wales by conveyancers or solicitors, so that they can present that bundle to the buyer in Queensland, in New South Wales. So I find with my clients that have bought in Queensland during the property boom, now a bit shocked by how simple it is to just sign a contract, and there's just a few flimsy pieces of paper in the REIQ contract and no protection for buyers who have absolutely no idea how the system works up here. So the law has been passed. We've now got the Property Law Act of 2023. Certain parts of it won't start until a date to be advised. But I wanted to bring the regulation because there's certain things that will help make that disclosure process and that due diligence process a lot safer for buyers. So we don't need to negotiate too many special conditions to make it tighter.
Yeah.
So some of the things now, a lot of agents do it anyway, but things like a title search is important. So we can check the name, the property details, a copy of the survey plan so you can see the number and that it exists.
Yep.
Certain pool certificates, certain body corporate certificates will be introduced if you're buying a building.
Okay.
And the other thing which will be really important, which is I think a long time coming, because a lot of contracts have fallen over because of due diligence, lack of due diligence inquiries.
Yeah.
So some of the things they're suggesting to be included in this disclosure statement that would be given to buyers. Of course, the name of the seller, that's a given.
Okay.
But any unregistered encumbrances, so things maybe that run or pass through the land, zoning requirements, contamination, environmental issues.
Yeah.
They're even talking about heritage, even the rates. As you know, that the rates is something your solicitor will do so that we can work out the adjustments just before settlement. They're suggesting all of that information
To be disclosed.
to be disclosed. A big thing for that is certain charges on property that have been introduced by the council. We want to make sure that they're cleared by the seller before the settlement, because certain charges, for example, land tax, it's quite a bit different to rates, but land tax is another example where it lives with the dirt. I always tell my client it lives in the dirt. It doesn't live in the pantry or in the Tupperware container that's going to leave the house. It's in the dirt. It's sort of like a fertilizer. So when we're doing the adjustments, we want to collate all those government certificates. So if there's 5, 10, 15 grand in land tax or another charge sitting on the rates bill, that will need to come out of the settlement balance the seller will get at the end of the day. So these are just an example of some of the things that...
So these are the changes that are coming up?
These are the changes that are coming up.
Okay, yeah.
Some of the other changes that have made it a bit less of a cowboy environment in Queensland is the disclosure of tenancy agreements, whether the rent has been increased in the last 12 months. There's now some standard boxes for the agent to complete in the contract about the rent increases. The other one that's been introduced is the smoke alarms. So that's been in motion for a couple of years now and will slowly be rolled out to all properties in Queensland. Just to make sure that they're compliant before settlement. If they're not compliant, buyers are entitled to a small deduction of 0.15% of the purchase price. So that they can go and do that once they become the new owner, or ensure it's done before they rent out the property, because the tenancy laws also require that to be compliant.
Brings me to my last question, I'd say here. The last stage of any transaction in our field is settlement. And things have changed dramatically there over COVID and everything happening. And we have this new beast called PEXA. Okay. So we all know what settlement is. It's the day names are transferred over, people are paid, banks are paid out, everyone get paid, and the new owner gets possession of the property. But if you could just explain how PEXA works, how settlement works, because I think everybody know the old style of buying a property, was this conveyancers would go to a settlement agent, and checks would be exchanged, and
they lodge the physical documents with the land titles,
and stuff.
Deposit checks into people's accounts.
And
the old
COVID has changed it all.
Entirely.
Yes. Tell me more about that.
So New South Wales had this system a lot earlier than Queensland. Then Queensland, then they made it mandatory to do electronic conveyancing settlements. And then recently Queensland introduced the electronic settlement as mandatory. So those same stakeholders, the banks, the parties, solicitors, we all join a digital workspace. This digital workspace is on the internet, it's secure, and we create a new workspace per transaction. So all the participants in the transaction, except the real estate agent, comes together. And we do the same things in terms of the bank uploading the money, preparing the transfer and ownership
Yeah.
documents, populating our respective clients' details,
Yeah.
balancing the money with the adjustments.
Yeah.
And then on the settlement day, if there is a bank involved, the bank that's holding the current mortgage,
Yeah.
they will be there to collect the settlement funds to
Yeah.
release the mortgage,
Mhm.
and then they will release the mortgage off the title.
Yeah.
And similarly, if the buyer has a bank, the bank will upload the money.
Yeah.
It's my understanding all the pool of funds that are needed for the transaction are held by the Reserve Bank.
Yeah.
They sort of go into this holding pattern,
Mhm.
and the solicitors, we all give directions where all that money needs to go.
Needs to go, yeah.
And it's all transparent. Both sides of the transaction can see the same
Same thing,
information, so we can cross-reference and make sure that we're all on the same page. And only
Yeah.
when we agree with all the figures and all the details and the documents prepared
Yeah.
correctly do the solicitors sign off. The money is then allocated per the solicitor's instructions to all the parties,
Yeah.
and the government receives the transfer documents. So they will electronically change names, they will remove a mortgage, they will add a mortgage, and whatever else.
Kind
And in
of
some
happens automatically.
it all happens automatically in
spot.
about 15, 20 minutes, and
20 minutes,
sometimes
yeah.
even sooner.
So, okay.
So it saves, it's a huge improvement in cybersecurity.
Yeah.
In security, because in most cases, the client can hold the shortfall amount, so the amount they need to settle above what the bank is giving them.
Yeah.
They can often hold it in their own bank account. They don't
Okay,
need
yeah.
to transfer it to lawyers'
Okay.
trust accounts.
All right. Yeah.
Because in the old days, the lawyer would have to hold the money, and then he would send his secretary to draw the checks from
yeah.
the bank.
Yeah.
So that reduces the need for those transfers. Of course, there's still some risks when it comes to inserting bank account details electronically into the system. But if you use PEXA, they have this app called PEXA Key,
Yeah.
which is included. Your clients can safely download it. It has various levels of protection, and you can send and receive bank account details via that app on your phone. And it also comes with guaranteed insurance. So if the PEXA system is hacked through no fault of the solicitors,
Yeah.
and money is unfortunately misplaced, PEXA will step in and take responsibility for that. Of course, if money goes missing and it was being directed to a law firm, the law firm would generally have to turn to their insurer, and it can become really complicated.
So there's really no danger or fear that the buyers or sellers should have using the system.
No, absolutely not. In fact, I say the opposite. It's a lot safer to use. It's a lot quicker. There's a lot more transparency between the buyer and sellers. Solicitors, there's more transparency. With the bank, there's less risk of the transaction not happening because there was traffic on the way to the settlement agent or something. And it's digital. It's covered by multi-layers of cybersecurity. It's backed by now a publicly listed company, and it's just the preferred way of settling transactions. There are some transactions, of course, due to lengths of name or people have single names where we can't use PEXA.
Okay.
So there are some rules around where you can and cannot use PEXA.
Okay,
They're slowly rolling out more variations.
Yeah.
So on the
So
rare
there are
occasion,
still settlements that don't happen in PEXA. It's not 100% PEXA at this stage.
no, and there's certainly still a large volume that still settle
that
on
paper
paper.
settlements, as you say. Yeah. Okay, cool.
Particularly because we're becoming more multicultural. There's a character limit on the Land Titles Office, which PEXA can't work around in Queensland for the time being. Or certain cultures, they only have one name, like Madonna. You can't currently use PEXA for that. So there's still a large volume that happen on paper, or if the PEXA system crashes, which isn't often, you will resort to doing it.
But we will be evolving to go where one day we'll be 100% online.
I'd say so. It's not far away.
John, there is some good news for first-home buyers, right? With the stamp duty part of things. We have the limits have moved in Queensland.
Yes.
What are that? Could you speak a bit about that?
So this is welcome news from the current Premier,
Yeah.
Stephen Miles, in wake of the cost of living crisis that's gripping everyone.
Yep.
So, fortunately, the Queensland government has increased the threshold for first home buyers.
Yeah.
Previously, before the change, it started at 500,000
Yep.
or 499,000,
Yeah.
and then you would pay a scaled amount
Yeah.
up from there. So now they have increased the stamp duty threshold from
Yeah.
500 to 700,000,
Yeah.
just to be more in line, not only with the cost of living crisis,
Yeah.
but also the house price increase that we've seen as a result of COVID.
Yeah.
So that's increased from 500 to 700, and then it phases out.
Okay. So if a first home buyer is buying something up to 699,000 and under, they pay zero stamp duty.
Right.
Right. Now, when they go above, say it's 720,000 or 710,
Yes. They pay a scale through to 800,000.
Oh, there are tiers that
Tiers
they pay
through.
Okay,
yes.
cool.
So, some examples in terms of the cost savings that they printed recently. So there's an example here on the government website where Wendy purchased a home in Pimpamar on the Gold Coast for 700,000. So bang on where the scale starts to increase, not $1 less.
Yeah.
So in that case, Wendy would receive the maximum concession. So the previous duty payable was 17,350, and on the new transfer, she'd pay zero. Another instance where the Brisbane mum Layla has bought an apartment in 8 Mile Plains for 555,000. So that's would have previously cost her about 10,000. So now she'd be paying zero. So, but I suppose the way to understand it is that all eligible first home buyers could be eligible for a maximum concession of 17,350.
Yeah.
But there's got to be a property value of 700,000.
Yeah.
So I'm not sure, in my experience, it's still really aligned with the property boom we've seen in Queensland.
Yes.
Because a lot of buyers from down south are buying, and that's increasing the prices. So I still think it's very difficult for first home buyers to save the 20%, have the registration fees, the lawyer fees, the moving costs, stamp duty costs. So anyway, it's
definitely a struggle there.
It's a help. It's a help from the government. We don't get many handouts from them.
No worries. John, thank you so much for your time. Guys, heaps of knowledge over here. So much to learn. And more than learning actually is of being aware of what you should have taken care of before you even start looking for a property. Like I mentioned in the previous video, buying or selling a property is a very, very simple transaction. It only gets complicated when you are not equipped enough.
Right.
So if you have the right people on your team, you're doing the right things, it's a very simple transaction. And I think from a legal perspective, John has covered everything. So thank you, John.
Thank you for having me. Cheers.